All right. So let's see here if people are joining in from the waiting room. Yes, we got people joining. Welcome, everybody. So we're just going to take a minute or two and let people join in here with us. But I do want to welcome everybody who's here so far and all of you who watch this afterwards with the recordings that we send out after this session. Today, we'll do a webinar, which I'm sure all of you know, on legal tech on surrogacy in the United States. Something I know that a lot of us intended parents, especially first-time intended parents, are very interested in. And luckily enough, we have somebody amazing with us to talk us through that part, which is Andrew here, who's sitting here. He's going to introduce himself as well later, but it's great to have him here. He's amazing in many ways, especially when it comes to the legal landscape of surrogacy. And on a personal note, my attorney for my last surrogacy journey. So if, I trusted him with my journey and you can trust him with yours. So we'll have him talk a little bit about those aspects. As I see, we have some people coming in still, but we'll get started a little bit. And I promise we're going to end on time. And we're going to end with a Q&A session. So all of your amazing questions you've been kind of holding on or not daring to ask, like this is the time to ask somebody very experienced in the legal aspects of things. If I can contribute, I'll try, but Andrew is definitely the expert in this field. So we're going to do that. So yeah, let's get started. And there is a Q&A button somewhere on your screen. I'm not sure if you're on an iPad or computer. There's too many technological options these days, I feel like. But there should be a button like that. And feel free to press that anytime during this presentation and ask your questions as we go along. And we'll get to them in the end, we promise. Awesome. All right. So a little bit of logos, right? Nothing's wrong with branding. Andrew has his amazing background there as well. So you don't miss who's going to talk here today. The schedule today, it looks like this. So we're just going to do a brief introduction on myself, on Andrew, of course, and, who this agency is and this clinic is, and also about Andrew's firm. Talk about that a little bit. But we're really going to focus the vast majority of this time on talking about the legal aspects. So we're going to talk about U.S. surrogacy law by state. We will not go through state by state because that would take too long. Some of you have more experience already in this journey. Some of you have less, but we're going to try to do a little bit more of surface level, but feel free to go deeper inside with your questions, for example. So we're going to look at a couple of states. Andrew is going to walk us through maybe a couple of examples of, why is this state particularly esteemed to be a good state or, a less good state. Maybe point out a state or two that is, very great for surrogacy, maybe one or two that isn't as great and why, and just kind of have a general overview. And also look at an exciting thing that me and Andrew just spoke about, which is Michigan, the state of Michigan. When it comes to surrogacy, at least, there's some amazing news coming from there. So we'll discuss that a little bit as well. And then we will go through the legal process for an egg donation and surrogacy journey. This is going to be Andrew's field mainly to walk us through how does that work before the pregnancy, during pregnancy, what happens after the delivery of the baby as well. Which is also interesting, of course. We're going to go through some commonly asked questions. As an intended parent coordinator, I do speak with a fair share of intended parents, and there's definitely a couple of legal questions that stand out. It's going to be interesting to see, Andrew, if you agree that these are commonly asked questions. Maybe they ask you totally different things when they come to you in the end. And then we're going to do a Q&A. So that's going to be the agenda, and we'll see how that all goes. Okay, so today's experts, myself briefly before we hand it over to Andrew. I'm the international manager here at Hatch, which is our agency, and PFCLA, which is our clinic. So this is a bit unique to us. We'll discuss that a little bit later about what does it mean to have your own agency and clinic in one place. I'm also, more importantly, I would believe, a two-time father through surrogacy and egg donation myself. So I am an international intended parent based in Europe. So I've done that twice. I just recently had a baby 4 months ago, which is amazing. Once again, with the legal support of Andy and his team. So that's been great. Andrew, tell us a little bit shortly about yourself.
So I've been specializing in representing intended parents now since 1994. So it's my 31st year advocating on behalf of intended parents. A little more than half of our clients live outside the United States, unfortunately, because surrogacy is generally not legal outside of America, with a few exceptions. And I've been blessed now to have helped more than 28,000 couples start or expand their families through surrogacy. And we take a very holistic approach to our representation, believing that intended parents need to have an advocate through every stage of the process. So we're available to help Hatch clients from their match with the surrogate till they're safely home with the child, including securing citizenship for their baby.
Amazing. And you also do egg donation agreements, of course, and you do all of that as well.
Yes, sir. Egg donation, sperm donation, embryo donation arrangements as well. Anything related to third-party reproduction, we're there to assist, including guardianship agreements, power of attorney, reproductive estate plans, anything connected to having to start a family through assisted reproduction.
Perfect. Great. So now you know who we are and who you're speaking to. Just shortly walking you through a bit of, who we are more specifically, starting with Hatch and PFCLA. So Hatch and PFCLA were partners for a very long time, for about 20 years. After a very long time, we realized that we actually really liked each other. And we also thought that there would be a nice way to kind of combine forces together. So a couple of years back, Hatch and PFCLA combined forces in all possible ways, and we integrated in a program we call the Peace of Mind program. So the whole idea behind that was the coordination for the intended parents between the agency and clinic could be streamlined and more efficient. So done with one team, more or less. Financially, we thought that transparency didn't really exist in the way we wanted when it came to surrogacy, especially, but even IVF. So we wanted to create a program which had one fixed fee for both sides to be able to say to intended parents, like, we know this is confusing, we know it's somewhat scary even, but this is a fixed fee price for everything you're going to need, both agency and clinic. And that also covers, for example, IPs working with Andrew as their legal representation, the legal fees for doing that as well. And the last aspect and the vision of this program was the medical aspect. So we wanted to build a program that had medical assessments in the forefront. We wanted to make sure when a surrogate or donor is accepted to our program, a medical doctor has, for example, screened the medical records of the surrogate or donor already, or even done a uterus lining check on the surrogate, for example, something we order actually before we accept our surrogates today. So that's the kind of vision of that program, to have everything in one place, making it a bit smoother. We do everything non-medical on the Hatch side, of course, and everything medical on the clinical side, PFCLA, and bringing that together for one seamless journey for our clients and patients and intended parents. So that's what we've done so far. A little bit of numbers of Hatch very briefly, 33 years of experience. Andrew, is funny enough, you work with this agency much longer than I've been employed at this agency, which is kind of funny in that sense. So you work with our founder, Shelly, right? The founder of this agency.
Yeah, going back to 1994 when I first met Shelly, she true pioneer in this field.
Absolutely. So this was the first donor program in the US and became one of the first surrogacy programs as well. So it's been an amazing ride. 8,000 journeys, clients from over 50 countries. So if you are domestic in the US, obviously that's a part of, the services we provide, but also if you're international, wherever you can be, we work with clients from all over the world for this amazing journey. Success rate looks at basically, do you have a baby through this program or did you leave without the baby? Timeline, embryo transfers can be discussed in the consultation, what that means. This looks at, did you have a child or did you not have a child when you left our program? We work with amazing attorneys like Andrew here for the legal side of things. And we have amazing surrogate and donor candidates with that physician oversight. And why we always emphasize that more is because it's quite uncommon. Agencies don't have medical IVF physicians in-house. So, doing that medical records review, screening your surrogates, that will absolutely happen with any agency, but after your match usually, not before that match. So this is something that we've done to set us apart and set our surrogates and donors apart from, what we usually see out there in this field. Shortly about our clinic, the number of births, our transfer success rates. The clinic has also been around for about 30 years. So we have over 60 years of experience together in this joint program of the Peace of Mind program. And that's also most of the business we do today is actually surrogacy fertility versus, starting off as an IVF clinic for intended mothers doing transfers for themselves. So that's a little bit about Hatch and PFCLA, just to give you a little bit of, who are these people that are going to tell me about these legal aspects of everything. So Andrew, you told us a little bit about yourself. Just give us a brief introduction to your firm as well.
So yes, our firm handles a number of different legal issues, but mostly is focused on assisted reproduction. So we assist, as you pointed out, Edvin, with the surrogacy arrangements, as well as egg donation, sperm donation, and embryo donation agreements. We also provide trust management services, so we can protect our clients' funds throughout the journey to ensure any payments that go out, whether to their surrogate or egg donor, clinic, or any third party, has been reviewed by a lawyer first to make sure the contract authorizes those payments. We assist in the finalization of parental rights, securing birth certificates with the intended parents' names on it. And then we also work with their local attorneys back in their home country to address optional parental right actions that are available in certain home countries like the UK, to deal with international insurance to cover the newborn baby here in the United States. Will also help secure passports and citizenship as well.
Wonderful. And thanks for adding in that international aspect, because it is important as well to kind of, as international intended parents, we're always worried about, we know the US process works, more or less in the same way we think, but what happens when we come back home? And that's always a bit scary.
And as you know, Evan, we work hand in hand with their local attorneys. So many of our clients, international clients, will have a family attorney as an example, or an estate attorney. And we coordinate with them throughout the entire process from the contract phase till they're safely home with their child.
Perfect. All right, so that's a little bit about us. So let's look at this, state of surrogacy and how it looks in different states. And this is a really good map that we've swiped. So the sources at the bottom to give that clarity on, how does it look? Which states are considered to be surrogacy friendly, if we put it that way, which are kind of a bit cautionary when it comes to using a surrogate, and which ones are totally restricted or prohibited. So I would like to start with you, Andy, a little bit, and just kind of ask you, we get a lot of intended parents that ask obviously about different states, where should my surrogate be in, why should she be there, and what should I consider. So can you just briefly just walk us through first, like, what makes the state more or less favorable for surrogacy, and is there anything specific that makes it that way and intended parents need to consider?
Yes, so let me highlight three important issues. There are a lot of variables, but let me hit the three most important issues for today and what makes states friendly versus states we recommend you stay away from. First and foremost, surrogacy in the United States, unlike most countries around the world, is regulated at the state level. And that's what this map reflects. The dark green states are states where you can safely move forward with surrogacy. The states that are in gray, including Michigan, Nebraska, and Louisiana, criminalize commercial surrogacy. Other states that are highlighted in light green, like Arizona, as an example, and Indiana, they find the contracts to be void and unenforceable, even though there's no criminal penalty. So the first issue we always have to look at, the threshold issue that Hatch does such an amazing job of, is recruiting surrogates that come from states where we have a valid and enforceable contract. Now, why is the contract important? Let me quickly highlight three reasons. First and foremost, we want to make sure the surrogate can't change your mind and keep your baby. So the states that are in green, the intended parents are considered the legal parents. The surrogate does not have any parental rights, and the intended parents will get immediate custody of their child. Contract is also important so we can protect the health of the baby during the pregnancy through lifestyle restrictions, diet, exercise, travel, sexual activity, COVID protocols that we put in place to give your baby the best chance of being born healthy. And then the other reason these dark green states are so attractive to our clients is that it allows us to protect the intended parents from any financial liability or legal exposure that could come up. As an example, if their surrogate suffered a major medical complication, we can insulate them from liability, both under the contract and through the use of insurance. So that's the first important issue to understand when we select a surrogate from any of these states. The second issue that's very important, particularly for international intended parents, is how do we get your names on the birth certificate as the parents of your child? And unfortunately, in the United States, that issue also is left to the states to decide. And there's two basic approaches to finalizing your parental rights. There are pre-birth order states. Again, those are the dark green states, which allows us to go before the judge about 22 weeks into the pregnancy to have you declared as the legal parents, so your names are entered on the original birth certificate. Other states, unfortunately, follow the European model, in which the surrogate is considered the mother. Her name will go on the original birth certificate. The intended parents then have to do a post-birth step parent or second parent adoption process. And we generally don't recommend those states for our international intended parents because that's going to delay your return home. So our goal, working with Edvin, is to find surrogate for you in a state that we can do a pre-birth order, have you ready to go home with a passport in hand as early as 2 weeks after your baby is born, so there won't be any extended delays. And then the final issue, not reflected on this map, but unfortunately something we've had to deal with recently over the last couple of years, is abortion. So for intended parents who would consider terminating a pregnancy in an unlikely event that there is a serious physiological or chromosomal abnormality with their child, there are certain states, places like Texas as an example, where abortion is significantly restricted. So we may recommend a surrogate from a different state depending on the intended parent's philosophy on termination.
Yeah, great. Um, and with these different states, obviously, now we see kind of which ones are surrogacy friendly, which are kind of cautionary, and which are restricted. And before we move on with the question, just briefly touch upon, the elephant in the room, the big red circle over Michigan there, the states. So
Sure.
just mention a bit about that because as you and I know, Michigan recently passed some legislation or will pass legislation on this issue of surrogacy. So what's happening in Michigan and what's going on there?
Yeah, good news with Michigan. It had been a felony up until this year to move forward with a commercial surrogate arrangement, as well as prohibiting anyone from helping someone move forward with the Michigan surrogate. But the good news is Michigan has embraced surrogacy. As of March of 2025, we can move forward with surrogate matches in Michigan. Unfortunately, even though the new law has passed, it doesn't become effective until 4 months after this current legislative session ends, which is supposed to end in November. So by March of 2025, we can add Michigan to the list of states that we can safely work in. And the new Michigan statute is among the most progressive in the country. So it'd be a great state to consider as well for intended parents looking for a candidate in the Midwest.
Wonderful. And one thing to touch upon that when you mentioned, which I really want to pick up on, is progressive state and one of a great choice for surrogacy. Can you just touch upon briefly the commonly asked question about California? When it comes to California, I meet loads of intended parents that come to me with the assumption that if you do want to do this in the safest way and the best way possible, you are required to go to California to have your surrogate there, for example. Can you just touch upon how you view that from a legal point of view? Is that correct that to be the safest and have the best journey, you need to be in California? Or why are these other surrogacy friendly states considered friendly if California isn't the only option?
Yeah, the good news is today we have many options outside of California. Historically, California has sort of led the country with respect to surrogacy laws. In fact, we were able to get the first pre-birth order. I was able to do that back in 1996, where prior to that, everyone that was moving forward with the surrogate arrangement had to do a step parent or second parent adoption. So California sort of served as the model for other states. Now, depending on the type of surrogacy we're doing, marital status, genetic connection to the child, we can have up to 44 states plus the District of Columbia that we can work in, and the results are identical to California. So no difference between California and, let's say, a place like New Jersey or Maryland or Maine or Illinois, but certain factors have to be met. So California still remains a very, very progressive state. So if we have international intended parents who have no genetic connection to their child because they're working with the sperm donor and egg donor or have donor embryos, then we may recommend a state like California that doesn't discriminate based on genetic connection to the child. But right now, there are 44 states plus the District of Columbia that we can work in. And then as of March of 2025, we can add Michigan to the list. So I certainly encourage my clients, look for the best available surrogate. Don't focus on the state she comes from.
Perfect. And why we also want to emphasize that because of timeline and costs, right? Working with California surrogates, it takes usually longer to match with the California surrogate. Compensation wise, it's usually higher, etc. So for you watching, like that's the reason for this question as well, to not prolong your process more than it has to be prolonged, or also incur more cost than you need to incur. So thanks for making that clearer for us, Andrew. And generally, what else do intended parents need to think about then? Let's say you come as a domestic or international couple. Are there other considerations? Obviously, the surrogates background, etc. It's all important, but what else do they need to consider? You talked about genetic link, for example. So is there any other kind of criteria they should think about when they look at different states?
So absolutely. So if intended parents need to use an egg donor as an example, the ability to get a pre-birth order is significantly impacted. So where I've talked about 45 jurisdictions we can safely do surrogacy in, if donor eggs are involved, we may reduce the recommended states to 25 because of the ability to get that post-birth parental order. which we want to avoid for international intended parents. So right now, there are 25 jurisdictions where if donor eggs are used, we can get a pre-birth order. But another 20 jurisdictions where there may need to be a post-birth order, which we want to avoid for international intended parents. So genetic connection to the embryos is a significant factor we have to consider in selecting a surrogate. We also have to look at marital status. Unfortunately, there are some states in America, Utah being a great example, that permits surrogacy, but does require two intended parents who are married to one another with at least one intended parent genetically related to the child. So when we do our intake, when we do our initial consultation with all intended parents, we'll collect all of this information, marital status, genetic connection. By the way, the genetic connection also has an impact on citizenship. Your baby will automatically be a US citizen by virtue of being born here. But we also have to get citizenship for the baby from the intended parent's home country. And in most countries around the world, citizenship passes from the biological parent to the child. So that's another issue. We oftentimes will have international intended parents that may live in one country, but they're a citizen of a different country. So we're going to review all of those issues as well and lay out a plan for how we're going to secure citizenship for the child as well.
All right, I really like this map and talking about it this way because I think it's very useful. I a bit wish that we only had this to speak about now because I have more questions for you, and I think it's a great way to visualize this and kind of give it a bit of a pragmatic kind of approach. But we're going to leave this map for now, and we're going to go forward a little bit and speak about a couple of different things. But I hope you are watching this have found that map interesting. This is just what you talked about a bit, Andrew, about what other considerations do we have: genetic connection, marital status, etc. How about our same-sex couples out there, and Andrew? How does it look for them when it comes to available states, etc.? What's the situation there?
So we're going to recommend 25 jurisdictions right now for our same-sex couples because by definition, one of them will not be genetically related. They'll need to work with either an egg donor or sperm donor. And the reason we're going to focus on those jurisdictions is those are the states that whether we work with the donor or not, they're going to allow for a pre-birth order. And let me quickly describe this pre-birth order process. The pre-birth order process allows us to go before a judge during the pregnancy to have you declared as the legal parents. That application will be made about 22 weeks into the pregnancy, ensuring that your names go on the original birth certificate as the parents. And that then allows us to get the passport so that you can return home as quickly as possible. So whether you're a same-sex couple or heterosexual couple, we're going to focus on those pre-birth order states. There will not be any difference in the process. Unfortunately, there are some states in America that whether you're a same-sex couple, heterosexual couple, even a single individual, that will put the surrogate's name on the birth certificate. And then in those jurisdictions, we have to do a post-birth order to remove the gestational carrier's name from the birth certificate and replace it with the other intended parent or have it left blank in case of a single intended mother or a single intended father. So for same-sex couples, at least for our international clients, there will not be any difference whether we work with a surrogate from a state that allows for pre-birth orders or contemporaneous birth orders at the time of delivery.
Got it. Good. Just to cover a bit of the difference. And so basically, a married straight couple are basically have, a smorgasbord of different options to work with, but a bit more restricted for those, especially international, who are maybe same sex, or for those who don't have any genetic link to the baby.
That's absolutely correct. So bottom line, if we have a married heterosexual couple, both genetically related, we're looking at roughly 45 jurisdictions. If donor eggs or donor sperm are used, we're probably going to focus on 25 jurisdictions instead.
Perfect. All right. So the process, you've described a bit of that pre-birth order, post-birth order, which is great because that's also one of the most commonly asked questions about that, which is, understandable how it works, but it's always better to hear it from an attorney. So when we walk through this process, Andrew, can you just walk us through, first of all, before you even have a pregnancy occur, from the legal perspective, what needs to happen before that can kind of proceed?
No, absolutely. So initially, Hatch will present surrogates to the intended parents, a profile so they can review to see if it is a compatible match. We will assist in reviewing the profile with them, explaining the underlying laws, addressing that candidate's health insurance, because that's an important factor we haven't talked about. We need to make sure that surrogate has the appropriate insurance coverage in place to cover the pregnancy, labor, delivery, and any complications that come up. So we'll be available to assist with that. We'll go over the agency agreement, the Hatch agency agreement with the intended parents, explain how that peace of mind program works if they have any questions. Although you do such a great job with the onboarding process, we generally don't have to answer any questions, but we're available as a resource to assist with that. And then once a match has been consummated, the parties decide to work with one another, then the screening process begins. And that, psychological screening, background check, medical screening, generally the background check and psychological screening will have already been completed. So the next step would be for them to go to the IVF doctor for a full medical screening. Once that medical screening is complete, we'll then draft the contract between the intended parents and their donor, or the intended parents and their surrogate. Contract process will take about 2 weeks to complete on the surrogacy side, a little less than a week on the donor side. Both the gestational carrier and egg donor will be required to have their own independent lawyer to review the agreement, answer any questions they may have. But since we've done so many of these arrangements and have worked with most of the law firms around the country, we're able to streamline the process, anticipate any changes those lawyers may make, incorporate it into the first draft of the agreement, because we're mindful that you're anxious to become parents, and we don't want to delay this process at all. So we'll be able to do the legal work as soon as the medical screening is complete, allowing the doctor to issue a medical calendar almost immediately after the contracts are signed, so we don't have any downtime at all for the intended parents.
Wonderful. And when it comes to the surrogacy agreement, I feel like we often get a bit more of questions on, what does that agreement entail, etc. Is there anything specific in those agreements, when intended parents, when you work with them or with surrogates for that matter, is there anything specific that usually, want to add on there? How much of kind of a draftable document is that? Is usually a question we get, is that set in stone? Can we, come with our own requirements? Like, how does that work?
So this is your pregnancy. So you have the right to incorporate into that contract what your expectations are for the pregnancy. Now, there's certain things that are automatically set, like the surrogate's compensation and reimbursement, and you'll be provided with that information before a match occurs. So, going into it, here's what this process is going to cost. That generally won't be adjusted. But everything else is based upon what your goals are out of this arrangement. So if you want your surrogate to eat organic food or practice yoga or avoid travel, we build all of that into the agreement. If you want her to see a specialist or deliver at a certain particular hospital, that gets incorporated. The amount of contact you want to have with your surrogate during the pregnancy, after birth, that will be addressed in the agreement. And then we'll talk about other issues, such as the birth plan. Who's going to be in the delivery room? Who cuts the umbilical cord? Who holds the baby first? Do you want your surrogate to pump breast milk? All of these issues will be addressed in the agreement, and we work directly with Hatch because as you're sharing information with them, they'll share it with us. So we're not reinventing the wheel. We'll have all of that information. So when it comes time to draft the contract, we'll have another call just to make sure that we've addressed all of the points and then send the draft agreement to you. We'll sit down over a Zoom call, take a couple of hours to go over that contract, revise it so that it reflects your expectations for this arrangement. And once you give us authorization, it will be sent to the donor or surrogate's attorney for review.
Perfect. And just a good thing to touch upon. I like that kind of, exemplifying, that there are sometimes very detailed things in there and sometimes it's more kind of like broader picture, but that, nothing is really off limits as long as everybody agrees in the end that that's, the way it should be. I do see you have questions coming in, so keep them coming. We're going to address them in the end, but you're doing a great job with those. I can see them pop up, so don't worry. They're still there. Okay, so this is before the pregnancy. We have this agreement in place, which is great. The agency agreement, donor, if that's relevant, and surrogacy agreement. So now the kind of foundation of the journey is kind of set. So what happens then during the pregnancy? You've touched a little bit upon this during that map we looked at, but go ahead and walk us through a bit of, if there's anything else you want to add on this during the pregnancy.
No, of course. So let me give you the timetable for the pre-birth order process, and I'll briefly touch upon the post-birth order as well. For the pre-birth order process, we're going to wait till the completion of the first trimester, so about 14 weeks into the pregnancy. We'll begin to circulate paperwork to you, your surrogate, as well as your IVF clinic. For the intended parents, it's a 3 or 4 page document that we will generate It's called a declaration under penalty of perjury. It's just a written statement under oath that describes the arrangement you have with your surrogate, provides some demographic information that's required by our U.S. Census Bureau that tracks all live births in the United States. But it's about 3 or 4 pages long. We'll email it to you. If it's accurate, we'll just ask you to print it out, sign it, return it to us, and you're done. There's nothing more you'll need to do. We'll collect those documents as well from your gestational carrier and IVF doctor. And then about 22 weeks into the pregnancy, which is when your baby is considered medically viable, we'll submit the stipulated paperwork to the court. You don't have to fly over. There's no appearance. There's no home study or social worker visit. Everything is done by stipulation. And usually within 2 to 3 weeks of us filing that paperwork with the court, the judge will return back to us a parental order. It'll either be a judgment of maternity and paternity, or a judgment of paternity, or a judgment of maternity in the event of a single mom. That judgment declares you to be the legal parent. It terminates any rights a surrogate has, and it orders the hospital and Department of Vital Records, which is the governmental agency that issues birth certificates here, to place your names on the birth certificate as the parents of your child. Typically, that judgment will be issued by the end of the second trimester. So by the end of the second trimester, the legal work is effectively complete. You have been declared the legal parents. And the last 3 or 4 months of the pregnancy is just our office working with Hatch to plan for the baby's arrival at the hospital, taking care of all the birth plans, securing a private room for you, dealing with the financial aspects for your baby's newborn care. Now, let me just quickly mention post-birth orders. There are a handful of states in the United States that, even though they don't allow pre-birth orders, they do allow expedited post-birth orders that would still allow us to get you home within 2 to 3 weeks after the birth of your child. States like Florida, Virginia, Minnesota, as an example, even though they don't allow final pre-birth orders, they do allow for an expedited post-birth order. So in those states, we will generally bring a pre-birth order application, but it's only an interim order that will declare you as the parents. And typically 72 to 96 hours after your child is born, we'll have the final post-birth order. Still allows your name to go on the original birth certificate, still allows us to meet that time frame of you being able to leave the country with your child within 2 to 3 weeks after the birth of your child. So I just want to be clear that while there are certain states that do require a post-birth order, we can still maintain that timeline so that you can return home. And not to get too deep into the weeds, but let me also quickly point out, certainly if you work with PFCLA, since the embryo transfer will occur here in California, even if you have an out-of-state surrogate, we can still take advantage of California law. So you may not want to work in a state that requires a post-birth order. But if PFCLA does the embryo transfer here in California, we can invoke California law, even with an out-of-state surrogate, get a California pre-birth order enforced in that state, ensuring your name goes on the original birth certificate and avoiding any kind of delay in returning home.
That last part always sounds a little bit like magic to me. But that's great to know.
Yeah, the California surrogacy statute, which I actually had the good fortune of drafting, I recognize that many of my clients would not be able to work with California surrogates, but wanted to make sure they had the kind of protections that California affords. So we're able to still use California law in many states whose laws are not quite as favorable as they are here.
That's amazing. And just hearing how you've been involved in that inception of those kind of things, Andrew, is just amazing on a side note of things. I never knew.
It makes me feel very old.
Makes you feel very old, yeah. Okay, so what happens, briefly, give us a 1 minute rundown, because I see that people have a lot of questions. I would love to get to those. So just give us a bit of a rundown quickly. What happens after the delivery then? You've touched upon this a bit, but.
Sure. So once the delivery occurs, we'll work with the intended parents to have Vital Records issue a birth certificate with their names on it. And then we'll arrange to have a passport for them to return home. Your baby will automatically be a U.S. citizen by virtue of being born here in America. The United States constitutionally has something called birthright citizenship, which means if your baby is born in America, he or she is automatically a U.S. citizen without regard to your citizenship. The U.S. passport I can get in as little as 24 hours. We have a passport service that will work with you, meet you wherever you're at, walk through your baby's American passport application, And within 24 hours of your return flight home, you will have your baby's US passport, even if that means it being issued the same day by the passport office. Now, as I also mentioned, your child will be entitled to citizenship from your home country. However, those passport applications require a visit to the consulate or embassy, so it may necessitate a second trip to that consulate or embassy. But more importantly, it's generally taking 4 to 10 weeks to complete passport applications at these consulate or embassies. Most of our clients want to return home 2 to 3 weeks after their baby is born. So in those situations, we're going to send them home on a US passport, coordinate with their attorney at home to register their child as a citizen of their home country. But under the US passport, you'll have 90 days as a visitor to register your child as a citizen from your home country.
Amazing time frame with that US passport, I must say. We never did that with our last pregnancy, and now we have to go to Stockholm, to the embassy. We have to, go through a 4-day process with a lot of paperwork. So I wish I would just have said, no, hey, Andy, where's that passport service? Would have saved us some time for sure.
It's much simpler, yes.
All right. If there's ever a next child, that's what we're doing. All right. Great. Thank you so much. And sorry to rush you. I'm going to go ahead and shoot past this slide here. Everybody that's watching this will have this sent to them. But this is everything Andrew actually has already told us about, more or less. So I really want to have some time and focus on these questions because they are rolling in. And we're going to see if some of these questions are actually on there, so we don't repeat ourselves. So we'll get back to this if we see that we're missing some of these. But I feel like we've touched upon many of these different questions here as well as I rummage through these things. All right, well, great. So we're going to go through your questions just briefly. If you do want to speak to Andrew or me in the future, you're obviously very welcome to do so. We set up cost-free consultations for our potential clients to walk you through, for example, in my case, the surrogacy process with Hatch, egg donation process, how we think about things, how we screen our surrogates, how we match you with surrogates, etc. And Andrew obviously covers the legal parts of that. So feel free to email any of us or visit our websites to set up that call. In my case, you can also scan this QR code. I felt very technically advanced when I put that together. So it takes you to my Calendly links. You can do that as well. But yeah, let's see what kind of questions we have here, because I felt like they were really rolling in. So Andrew, I think you're going to have a lot of work to do now. Let's see if we have some exciting things here. I'm just going to open this up. It always takes me a second. Okay. So we touched upon this a little bit, but we have the question of what's the best and easiest state in the US to take, the legal actions in, and which states you recommend. I feel like you covered a lot of that. Do you want to point out, even with amongst the surrogacy friendly states, are there a couple of ones that kind of stand out, or is it more generic between those states?
It's a really important question. So a lot depends on the unique circumstances of the intended parents. Are they married or not, genetically related or not to the child? I should also bring out another point because, obviously many of Hatch's clients come from Europe. There are certain countries, particularly if we have a same-sex couple, where it is important that we be able to get 2 birth certificates. And I don't want to get too deep into the weeds, but with some countries, we may need to have a birth certificate with the intended father's name on it and the gestational carrier to satisfy local laws, and then a second amended birth certificate that will have both parents on it, whether it's 2 dads, 2 moms. Believe it or not, in certain states, we can get a birth certificate that has 3 parents on it. So if it takes a community to raise a child and the intended parents, there's 3, there are certain states that we can get 3 parents on a birth certificate. So we'll go through this with the intended parents as they start looking at profiles to recommend what states are best. And let me just give an example. Pennsylvania and Ohio, really, really good states to do surrogacy if we have 2 intended parents that are both genetically related. But there's a handful of counties in those states that if an egg donor is used, the result is very different. So what we really have to do is analyze each case on a case-by-case basis to look at the intended parents' needs, desires, goals, and timeline, and then recommend states. So are there certain states that I can tell you just across the board are better than others? Yes, but in a state like California, which for an intended international parent who has no genetic connection to their child, California, Maryland, New Jersey, the District of Columbia would certainly be better than other states. But again, for many intended parents, most of the map will be available, but we do want to go through with them what their requirements are, and then recommend what states would be best for them.
Yeah. So it makes sense that it's more situational than just kind of saying that all of these are kind of generically good or bad. So like we have this question about, how many states are friendly for unmarried opposite sex straight couples who both have a genetic link. They're using their own, genetic materials.
So roughly 40 states will not discriminate based upon marital status. And even those that do, with a couple of exceptions, there are creative ways to deal with it, among other things, applying California law. Again, so if you were to use PFCLA and the embryo transfer occurs here in California, in a state like Texas, as an example, that does require two intended parents that are married, we can get around that marriage requirement. But roughly 40 jurisdictions, including the District of Columbia, would be great states to consider for unmarried heterosexual couples, both of whom are genetically related to the child.
Perfect. Someone's asking about cost. What about cost and the financial help, etc., for that? For those intended parents who are not financially very strong, and also, do you work with surrogates in other countries? So, to address the last question first, at Hatch we only work with U.S. citizens. So we only work with women that are in the United States that are U.S. citizens. On top of that, we have a lot of other requirements, both medical and non-medical. But if you look at that question, of citizenship or country, we only work with surrogates within the United States that are U.S. citizens. When it comes to financial aspects, there is no question about it that this journey becomes costly quite quickly. It doesn't matter if it's egg donation or surrogacy with IVF or anything else. The combinations, aside, it is a costly journey for sure to undertake. And I think all of us intended parents, myself included, the first time around, really one of the bigger key issues in the beginning is how do you finance that journey, for sure. So there is some financial help within the United States for domestic couples, everything from loans to other programs. So that could be available. Benefits from employers, for example, sometimes even cover surrogacy services, which is very rare for employers abroad. So there might be options for domestic couples or singles, definitely more than international folks, unfortunately. International folks are not really able to take out any loans, of course, or get any financial aid of that sort because we are not US citizens. So it's a much more limited situation, unfortunately, because the financial aid is required in many cases, and some people cannot start their journey because of that exact reason. So I think that's a fair way to kind of describe it. Andrew, do you have any experience of any other kind of financial options that you want to share?
Unfortunately, as you pointed out, it's limited unless there are certain benefits they have from their employers or their own insurance at home. What I should point out, though, is, Evan, we also have an open pro bono program at our office. So for any of your clients that are experiencing any financial hardship, we are happy to waive our fees if necessary, so that they can complete this journey. I do not believe money should ever stand in the way of anyone becoming a parent. So please know that our legal fees can be offset to help cover the balance of the journey if there is financial hardship.
Amazing. Perfect. That was a really good addition to that. I'm sure many people think. Okay, this is an interesting one, actually. I get asked this a lot. And how can requirements from the IPs that are incorporated in the legal agreement actually be enforced? So let's say, for example, a good example, like, if there's in the agreement, we should text once a week, but somebody continuously does not text, or as you took an example of, do yoga, somebody doesn't do yoga. How is it actually possible, if it is at all, to actually enforce this being done? I just want to add first, before you answer that, Andrew, that in the most cases with the Hatch surrogates, at least, we do not need to chase enforcement of these agreements. Our surrogates are very, very motivated to do exactly what's been agreed upon. And they've also agreed upon that themselves with their own legal advisor, own legal team. So just know, intended parents out there, that it's very rare that we have to go and chase and enforce these agreements, because surrogates do want to do what they've agreed to do in the vast majority of cases. But Andrew, if that's not the case, what happens then, and how can we enforce this if we can?
No, I want to echo what you said first, Evan, and that is that almost all surrogates will do whatever it takes not to disappoint you. Now, as I mentioned earlier, I exclusively represent intended parents, and because of ethical limitations here in the United States, I'm not permitted to communicate with surrogates once they're represented by a lawyer. However, I've been blessed to have a number of my clients ask that I be in the delivery room with them when their baby is born, and then it does give me a chance, not as a lawyer, but as a friend, to be able to communicate with the surrogate. And I will tell you that surrogates are living for that moment when they see you holding your baby in that delivery room the first time, and they don't want to disappoint you. So what Edvin says, it is extremely rare to see a surrogate act out, not follow the requirements of the contract because they don't want to disappoint you. But to the question, and it really is an important question, there is a certain leap of faith you're going to have to take. You know, she could promise you she's practicing yoga or eating organic food, but for all we know, she's laying on the couch, pounding McDonald's Happy Meals, and we're just not going to know about it, right? So that's where you rely on the expertise that Edvin and Hatch has when it comes to screening surrogates, doing all of that background work, making sure they match you with someone that shares your values and vision for what a healthy pregnancy looks like. And I will tell you, over the course of my career, over 31 years, and more than 28,000 surrogate arrangements and tens of thousands of donor arrangements, we have never once, not once, had to bring a claim against a surrogate or egg donor for any kind of material breach of contract. Now, we only work with the best agencies, and Hatch is the preeminent agency in the United States. We have never had an issue with a Hatch surrogate or donor not complying with the contract. But again, I can't promise you she's practicing yoga 3 times a week and only organic food because we don't have cameras up. There are other things that we can test for: drugs, alcohol, nicotine, even mercury levels to see if she's breached the agreement when it comes to eating sushi. But at the end of the day, you're going to have to rely upon the team you put together and then trust your own gut, your own instincts when you have that match call with the surrogate and get to know her. Is this someone that shares my values? Is this someone that I can see as a friend during the pregnancy? And if so, you're going to have a successful relationship.
Yeah, correct. And to not forget on the screening side of things, for example, like that's important to work with an agency that you also trust, because screenings in the United States aren't necessarily regulated in that sense for the agencies. You know, who do we accept? Who do we think is a great surrogate? Like there's models for it, you know, generally with the Society of Ethics of Egg Donation and Surrogacy, ASM, American Society of Reproductive Medicine, etc. But that's the important part of like speak to agencies, get that gut feeling. Who do you trust? We accept about 2 to 5% of all surrogate applicants, and we get hundreds of applications each week. So it's really important to find those kind of highly motivated, humanitarian motivation, great delivery history, no financial issues, no criminal records, et cetera, et cetera. That's going to make it much easier and likely that you don't have to go through those kind of issues with the contract and all of that. We have somebody from Canada joining us saying that in terms of how these cases are handled, Canadian IP with the US clinic and the US surrogate discussed in terms of how are these cases handled, and is the GC able to be compensated? Absolutely. So we have many Canadian intended parents in the program that join us on this amazing journey. I know that Canadian surrogacy is altruistic, not compensated, but it doesn't mean that we cannot compensate the surrogate in the United States for this journey. So as a Canadian, you can absolutely work with an agency and clinic in the United States, and you can do this very successfully and return back home safely. And I know, Andrew, you worked with some of our Canadian intended parents, and I'm sure you worked with many others from other agencies as well. So yeah, absolutely, Canadian intended parents, surrogacy, egg donation, IVF, accessible for you as well.
Yes, no issue at all. You're exactly right, Evan. The only country right now that we have to be really sensitive about is Italy because of pending legislation that may restrict their ability to travel internationally to work with an American surrogate. But with the exception of Italy and some little issues we have to deal with for clients out of Australia, from New South Wales in particular, the home country's laws are irrelevant to the matter that's taking place here in the United States.
Perfect. A quick question that I'll take before I shoot you another one, Andrew. And we're going to end this in a couple of minutes for everybody that's watching. I see you're still here with us, so it should be interesting enough, but we're going to give Andrew some time off as well soon. So we have a Toronto-based intended parent that is asking if we can supply a medically screened surrogate that can travel to Canada for the embryo transfer. So at Hatch, we don't do that kind of arrangement. So our surrogates do not travel anywhere else except for within the United States, of course, for the medical procedures. It's not impossible, though, that you can find an agency that does that. Could be that they exist. So it's not impossible per se, but with Hatch, we don't make any of those arrangements. We work with, our own clinic, of course. We also work with other clinics other than PFCLA. As long as they're in the US, our surrogates don't travel outside. So that's how it works with Hatch. All right, Andrew, should the legal representation from the IPs be from the surrogate state or from the agency or from the office?
The attorney for the gestational carrier should be in the state that she lives in so that that attorney can educate her on the unique laws in that particular state.
Perfect. So for international IPs have genetically tested frozen embryos that can be shipped, what is the recommendation on how to choose the IVF center? Should this be chosen based on the GC location and the recommendations? So first of all, in the vision of the Peace of Mind program, we really do not want location to be a factor for choosing a great surrogate or a great donor. What does that mean is that we cover, for example, all of the travel costs, etc., as much as it's necessary and as long as it's necessary, because we don't want you to make that decision making on, where's the location of the GC and the clinic, how much will she travel, etc. Andrew mentioned a little bit about California and the IVF centers having that kind of additional possibility to enforce that California law. So that could be a consideration. But if you mean more of, choosing the genetic carrier, the gestational carrier just because of that, travel, etc., then that's something you don't need to think about here, at least. Genetically tested frozen embryos shipped. So there are a lot of regulations from the FDA regarding this topic. It's hard to understand. We've made I think, quite a good attempt on our website, pfcla.com. We do have an article that was written by me and our chief medical officer, Wikin Shahakian, about this topic: importation of embryos, eggs, semen for surrogacy in the United States. There is restrictions for this importation. For example, any embryos created with the intention of surrogacy cannot be taken into the United States. There are other rules surrounding this, but there are also exemptions from these rules, depending on, let's say, somebody has a cancer diagnosis and they need to very quickly freeze their eggs or embryos for future use of any kind. So there are exceptions to these rules, but the general rule is that for surrogacy, to create embryos or anything else abroad and say, I'll just ship it over, it's not as easy as that. If, for example, somebody is using them for themselves, for example, in the United States, then that's possible. If somebody never had the intention of surrogacy, then that might be possible, but it's more situational. So there are exemptions. It's really important to speak to somebody who knows this. I know that, Andrew, you know a lot about this as well. And of course, us as a clinical center also knows this. So it's up to the doctors to discuss with a clinical professional, with a medical doctor. For example, our FDA officer is our chief medical officer, Dr. Wikin Shahakian. So anytime we have somebody that has this situation and we think there might be an exemption to the rules, we will have a call with our chief medical officer to assess the situation and make sure that we're not breaking any regulations. So generally speaking, no, but there might be exceptions for that rule. Speak to an agency or more importantly, a clinic. That's where you should get that advice from to kind of rule out if you can or cannot do that. Great. I think we are at the bottom of the list, which is great. You've all been troopers hanging in here, Andrew, you as well. Anything you wanted to add to that last bit, Andrew, or do you feel like that was kind of encompassed the picture of it all?
No, I couldn't have stated it any better. I mean, the big issue, as you pointed out, are FDA limitations on bringing in genetic material without them having been properly tested beforehand, and echo your recommendation that you speak to your IVF doctor about the ability to use those embryos here in the United States.
Exactly. And try to do that as soon as possible. If you don't have embryos or eggs, don't go out there, create them, and then come. It creates a lot of more issues. It's better to have that discussion before so you can get a good guidance. And our medical doctors are always ready to assist with that discussion. Recording will be shared, absolutely, so you can see it from the beginning to the end. All right. I want to thank all of you for those amazing, great questions. I want to thank Andrew especially, of course, for taking time off of your schedule to be here. We always appreciate having you on. So yeah, reach out to Andrew if you need any legal advice. Reach out to me if you want to speak about agency or clinic-related matters. And I hope that you have a good further research into this field. I know it's complicated. I know it's fun and scary, but we are here to help. So please reach out if you need us, and stay safe out there. And I wish everybody a great day or evening wherever you are in the world. Thank you so much, everybody. And Andrew, thank you so much for joining.
Thank you for inviting me, Evan. Best of luck to all of you on your journey.
Wonderful. Thank you all.
Take care.